those stairs. There's violations that go down. Good neighbors. The neighbors falling rude. Is there every time? Good neighbor. Security. Because of where he usually parks. It's right there. He says, that's your mom's flat bill.
Will be on the record in Bingham County case 006226316, State of Idaho versus Melissa Perkes. Ms. Perkes is present. She is represented by Mr. Manuel Murdoch, who is present. State is present, represented by Bingham County Prosecuting Attorney Paul Rogers. We're set for sentencing today. In that regard, we have a lot of people in the courtroom, and I'm simply going to admonish all of you that you are to maintain orderly conduct in the court. The court will not tolerate any outbursts or communication with any of the parties or the individuals in the courtroom. Mr. Murdoch, are you ready to proceed?
Yes, Your Honor.
Mr. Rogers, is the state.
Yes, Your Honor.
Ms. Perkes, at the time of your arraignment, on January 3rd of 2023, you were informed that an information had been filed charging you with murder in the second degree. At that time, you're advised of the potential penalties involved, your constitutional rights, your plea options, and the effect of exercising each of those options. You then pled not guilty and the matter was set for trial. However, on March 27th of 2023, you appeared before this court and pursuant to a plea agreement with the state, you withdrew your previous plea of not guilty and entered a plea of guilty as charged. The plea agreement provided, in exchange for your plea to that charge, that the state at sentencing would recommend a fixed and determinate period of 18 years. You agreed to recommend a sentence of not less than a fixed and determinate period of 5 years. As to any indeterminate portion of the sentence, the parties are free to argue the indeterminate period. The court will note that this is a non-binding plea agreement. This means that although the parties have agreed to make certain sentencing recommendations, this court is not obligated to follow those recommendations. In other words, the court, in applying the objectives of criminal punishment, may determine the fixed and indeterminate portions of the sentence based upon its review of the facts while applying the objectives of criminal punishment and the requirements under Idaho law, as set forth in Idaho Code Section 1925-21. As a non-binding plea agreement, if this court does not follow the recommendations of your attorney or the state's attorney, the defendant is not allowed to withdraw her plea on that basis alone. After you pled guilty, I ordered a pre-sentence investigation, and copies should have been furnished to each of the parties. Mr. Murdoch, did you receive a copy of that report?
Yes, Your Honor.
And have you had an opportunity to review that with your client?
I have.
Has the state received a copy of that report?
Yes, Your Honor.
Are there any clarifications or corrections to the report from the state?
No, Your Honor.
Any from the defense?
Yes, Your Honor. First, clarification or correction.
Just a minute, Mr. Brown.
Okay.
Go ahead.
Thank you. The first one we have is on page 7. It's actually on page 7 and 8.
Okay.
And with what we would do here is would move to strike a portion of the pre-sentence investigation report. And what we're looking at are the statements of Mildred Lorraine Spencer, Stacy Staples, James Norris, Timothy Sanch, Eric Heiner, and Hilton Kroll. The reason why we're moving to strike those is that they are not, although they have something to do with the defendant, and I don't mean to demean this in any way, but they are not victims under the statute. And I believe that the inclusion of those statements are inappropriate for what is required for the pre-sentence investigation report.
Mr. Rudd.
As far as family members go, Your Honor, under the statute 19-5306, the inclusion of where there's a deceased victim, you can include family members that have been emotionally affected by this. I'm not sure why that doesn't include these people, given their relationship with the deceased. And so I'd ask, they're short statements, and I'd ask the court to let them remain into the PSI.
Did you say Hilton Crowell as well?
Yes.
About Mr. Crowell. And that's spelled C-R-W-E-L-L.
Yes.
And Madam Reporter, I'll make sure you get copies of the spelling of all the names that are used here today.
If you're asking me that, Your
Yes.
Honor, yes. Perhaps that one doesn't fit under the statute, but I believe cousins and aunts would fit under the statute.
Your Honor, in response to that, the statute defines victims as immediate family members, and which are spouse, children, siblings, and parents, aunts and cousins.
You're correct in that analysis, but I also have discretion on the evidence that's admitted at sentencing. And under the circumstances, I'm going to go ahead and allow those statements to remain.
Okay.
So the objection's noted, it's overruled.
Thank you. The next one we have is on page 9.
Go ahead.
On the paragraph in the middle of the page, right above the section that's titled LSI-R domains,
Yes.
the last, that paragraph talks about the relationship with Ms. Perkes and Jace. The last sentence says that Ms. Perkes was adamant, "I don't know what happened that night. If I knew, I would say." What we want to add to that for clarification is that when she made that statement, she was talking about the actual fact of the stabbing. She does remember some details of that night, but she does not remember how he died. The next one is on page 12.
Okay.
At the top of the page, the second paragraph down states that, talks about her relationships with her siblings. It says she has a half-brother.
Yes.
Towards the end of that paragraph, it states that she has no relationship with any of these siblings. In quotes, it says, "I know who they are, but that is about it." And what we need to correct there is that is true regarding her sisters. That is not true regarding her brother. We'll talk more about that later, but she does have a relationship with her brother that's been very close.
Okay.
Okay, so the next one is on page 13.
Right.
At the very top of the page, it talks about Ms. Perkes' daughters, her relationship with them. The paragraph says that neither wants to speak with her right now.
On the top of page 13? Oh, here we go.
Yes, towards the end of the first paragraph.
Okay.
What we want to correct there is that she has spoken with her daughters. She does speak to them. Given that they're with her fathers, they're the ones that give permission or not give permission. But in her experience, the daughters have been willing to talk with her, and she has been talking to them. It's just subject to the father's permission.
Okay.
And then on that same page, in the middle of the page regarding the substance abuse treatment comments,
Yes.
in that section, the last paragraph that is not italicized says that she's never had any substance abuse treatment and does not feel she needs any. What we want to correct there is that she does feel like she would benefit from treatment and she would like to have it.
Okay.
And then on page 13, same page, the second to last bullet point on that page under the education employment section states that she quit school because she did not like it and chose to go to work. That's inaccurate. The reason why she got out of the program that she was studying at that time was because of health problems. They indicated to her that she wouldn't be a good fit because of her health problems at that time, so she withdrew. But she enjoyed her studies.
Okay.
The next clarification is on page 14.
All right.
Under the leisure/recreation section in the middle of the page, the italicized portion lists an area of concern that we disagree with. It says no involvement in structured pro-social activities, is often bored and or involved in criminal activities in spare time. In addition to what they've listed there, activities that she has been involved in and she enjoys doing, she was engaged with church, with the community dinner table. She enjoyed going to sports outings. So it was like it's not like she had no activities. and she has no criminal history.
Okay.
And those are other corrections and clarifications we have at this time.
Any objection to those, Mr. Rogers? Any objection to this court to relying upon the contents of the pre-sentence report and fashioning a sentence, Mr. Murdoch?
No, Your Honor.
Mr. Rogers?
No, Your Honor.
Mr. Murdoch, at your request, the court ordered a psychological evaluation on February 17th of this year, and that order was amended on March 16th of this year. It did get filed with the court. Was it your desire to have that evaluation considered by the court here today as well?
Yes, Your Honor.
Mr. Rogers, I assume you've seen a copy of that report. The court has reviewed that and will consider that report as well. We're now set for sentencing. Are there any witnesses for the state?
There are, Your Honor, under the Victim Impact Code, we do have 4 individuals that would like to present to the court.
Okay.
We have the father and mother, Lloyd and Susan Williams,
Lloyd.
and Susan.
Okay.
We also have, Mr. Williams had several children, and his ex-wife is here to speak on some of those children's behalf. And then her name is Amber Williams. And then Mr. Williams' 14-year-old daughter, Harley Williams, would like to address the court.
All right. As they come up, I'm just going to remind them that their comments are to be made to the court and not to anybody else.
Thank you, Your Honor.
So, Mr. Lloyd Williams? No, they'll go to the council table. At the table is fine. Just as long as I can hear them. All right, sir, if you'll pull that mic up close to you, if you'll please state your full name.
My name is Lloyd Williams, L-O-Y-D.
Thank you. If you'll please state your relationship with the decedent.
I am his father.
Thank you, sir. Go ahead.
Well, he was my son, obviously. And there's going to be a big hole where he sat on my right at all times. But they still have a lot of people on my right. But there's still going to be a big hole. And I will tell you that I felt betrayed. I will tell the court I feel she's dangerous. Very dangerous. The people behind me, many of them asked me to speak, and I'm honored to do so on their behalf. They are my family. They miss Jace too. It blew a big hole in their world. Hunting, fishing partner, and just all around guy to come help if you need help. Everybody needs punishment, Your Honor, every now and then, even me and you. And that's the way human nature is. And, well, on my bedside is a book, 1,387 pages. There's 10 rules in it. Thou shalt not kill is probably number 1, if I remember. I think it's an important one. Thank you to the court and all the officers and everyone involved. I probably haven't said enough, but I don't know that I have enough words. Thank you.
Thank you, sir. Mrs. Williams? Susan? Thank you, ma'am. If you will please state your full name.
Susan Ray Williams.
All right, and if you will state your relationship to the decedent.
And his mother.
Right. You're soft-spoken. These are being recorded. We have a court reporter. You can't see her because she's somewhere else, but she hears and sees everything that's going on. So I'm going to ask you to speak a little bit louder if you could.
Okay.
Thank you. Go ahead.
Welcome. Jace was my only child. God granted me a special gift when he let me have Jace. Jace was my best friend. He was my son. He was my companion. He was my partner in, pardon the word, crime. We had a lot of good times. He was my confidant. And now he's gone. I can't pick up the phone and call him and say, hey, I need help. Or let's just go for a drive. Let's go see what's happening up in the mountains. I don't get my text. He texts me every day. I love you, Mom. Have a great day. I don't get those anymore. I never will. Do I miss him? I don't have words to explain what I feel, how I am doing. I'm going to say a few things on behalf of my grandson and my granddaughter, because neither one of them are here. Well, my granddaughter is, but she doesn't want to speak. We were told that we couldn't talk to Mrs. Perkes directly. My grandson spent a lot of time in the apartment, in and around Miss Perkes. So did my granddaughter. Miss Perkes spent a lot of time in my house. She would call me when she was upset. I have no anger. I have no hate for her. But I will never forgive her for what she took from me. My grandkids will never have a dad to walk her down the aisle, hold his first grandchild, see them graduate from high school, go to their first prom, their first date, learn to drive. All of the important things in the life of your children. They won't have him there. My grandson misses his dad very much. He sent a text to his dad that said, Dad, please, with question marks. That tears my heart out. My granddaughter, she's the sweetest thing in the world, has the biggest heart. For her to say that she hates someone means that it's pretty dramatic to her. My grandson asked his mom, who has chosen not to speak, he asked his mom to please tell Miss Perkes that he hates her now. That she took one of the most important people away from them. And he, my grandson Dominic, has had an extremely hard time with this, with losing his dad. His daughter Harley has had a really, really hard time. The same. They won't come and stay at my house because it reminds them of their dad. Because I have his stuff at my house. It hurts them to come and stay. They'll come visit, but they won't spend the night. They won't come stay the weekend. Because that's where they spend time with him, was at our house, or with him and us. We would go fishing, we'd go hiking, we'd go to the mountains and take pictures. They'd go shooting with him. That's all been taken away from them. My daughter-in-law, that was, even though they were divorced, they were still friends. They still communicated, they still helped one another. That was taken from her. As with all the people in the courtroom, Jace is gone. Jace made friends wherever he went. He would put a smile on anybody's face. And now that light is gone. He's missed horrendously. I can't put into words the amount of hurt and pain that people have felt. I have no words to even begin to express how I feel. I would never, ever wish anything like this on anybody. I never thought I'd be standing here talking to you or to the court. I never in my wildest dreams thought that she would do this. Is she capable of doing it again? Yes, she is. She's manipulative. And she's, I feel so betrayed and so hurt that she would take someone that we love, she's supposed to love him, away from us. I don't understand it. I don't. I have no words. He has a cousin that came to visit in September of last year. And she was going to stop and see Jace, but her time was short, so she didn't get a chance to see him. She's here today. She will never get a chance to see him again, to say how much she loved him, or how good a friend he was, or joke, hang out, or anything else with him. And she's devastated. All of them are. Everybody in this courtroom. I will never forgive her. Jace would want me to, because he would. He would forgive her. But I can't. And for that, Judge, I am sorry. There's no forgiveness in me for her. I think her sentencing should be a hard one. She can talk to her daughters. She can talk to her mom. She can see her family. I can't see Jace or ever talk to him again. She gets privileges that he doesn't, or that I don't. Miss Perkes, I know I'm not supposed to address you directly. You betrayed his trust. You betrayed our trust. You betrayed our love that we gave to you. You took everything away. You destroyed my life, my work, my job, and how I interact with people. I will never forgive you for what you've done, ever. I would like to thank all of the officers that responded. I would like to thank the EMTs that did everything they could, and the doctors at Baylor Memorial for all their intense trying to save you. I thank you all from the bottom of my heart for what you did to try to save my son. I wish this on no one. It's indescribable. Thank you for your time.
Thank you, ma'am.
That's all we can do.
All right. Mr. Murdoch, then before I impose sentence, you may speak on behalf of the defendant.
Thank you, Your Honor. Your Honor, I've been doing this for coming up on 23 years. I've been doing this work. And this is a case that really stands out to me among all the others that I've done. And it stands out to me for several reasons. One is there's so many unusual factors present. And when I say that is, I'm talking about we have my client who has 0 criminal history. She's 36 years old. And nevertheless, she killed Jace. And that is so unusual to me. What compounds that is that we don't have a clear picture as to how that happened. You know, he died from stab wounds. My client inflicted those. But we don't know the circumstances of it. We can't remember. There's no other witnesses or anything to shed light on that, so there's some mysteries there. And as I've worked with Ms. Perkes and worked with this case, I'm understanding, as we're here today, of the weight of the situation and the sentiment that has been expressed by the family members. I can certainly understand, at least to a degree. I can't say I understand everything, but I understand that they're hurting. And I hope that with the passage of time, that they're able to find healing and peace. And I'm aware of that this is a weighty matter for the court as well. The court has to determine what an appropriate sentence is here today. And an appropriate sentence is one that is sufficient, but not greater than necessary to achieve the objectives of sentencing. And how I look at that is the law calls for a sentence that is not too harsh but not too lenient. There's a balance in between them. And this court will determine where that balancing point is. As I've considered this, and as I've thought about it and consulted with my client and read the reports, gone through the evaluations, and come to understand my client better, the sentence that I believe should be imposed here And when I make this recommendation, I understand that the plea agreement allows us to come in and request a fixed sentence of 5 years and then argue about indeterminate time. Well, we've talked about that, and my client agrees that would not be sufficient in this case. What we're recommending here today is a fixed sentence of 10 years. And then the rest of the time would be indeterminate, whatever the court feels is appropriate. And I'm aware of the fact that there's a risk in us coming in and making a recommendation to the court about our sentence. We're going to talk about my client and the factors that are at play in her life. And as I do that, the risk that I see is that people may look at that and say, hey, look, I had a hard life too, and I didn't go out and kill anyone. And as expressed by Jace's mother today, yes, my client is still alive. She can still talk to her family. She can still participate in life. Jace cannot. And while I recognize that those are the risks, I believe that we can transcend those and look to really what the law requires here to us to focus on. And not get derailed and just give into thinking that she is a horrible person and needs to be locked up forever. I don't believe that's what the law requires. And so the objectives of sentencing is set forth in Idaho Code 192521 are four. There's the protection of society, there's deterrence, there's punishment, and then there's rehabilitation. I believe that a sentence of 10 years fixed with a significant indeterminate portion does protect society. As I mentioned earlier, my client has no criminal history. She's 36 years old. For 36 years of her life, society has not had the need to be protected from her. And I understand the crime that she committed here is huge, one of the worst you can do. And I believe that that was a one-time thing. I believe that going to prison is going to protect society. I believe that when she comes out of prison, she'll never do this again. And with a significant amount of indeterminate jail time over her head, if she does get out of prison, she would be on parole. A parole officer would be watching her, would be helping her, would be making sure that she is not a problem for anyone else. And they could do that for as long as the time hanging over her head would be, even the rest of her life if necessary. So I believe that the sentence that I'm suggesting does protect society adequately. And it's not too lenient, and it's not too harsh. The sentence I'm suggesting also is not a walk in the park. When my client goes to prison, she loses her liberty. And when people see that, for anyone who is going to be deterred by a prison sentence, I believe a 10-year fixed with indeterminate time above that is going to have the desired effect. If that doesn't deter someone, I don't believe any sentence is going to deter them. So I believe that the sentence that I am requesting the court impose today, excuse me, satisfies the objective of deterrence. We look at punishment. my client understands that she needs to be punished. And today the court is going to punish her. It's going to impose something that will, that will be a great punishment on her. And I can tell the court that since this happened, her punishment began. And I'm not talking about just the jail time, the loss of her freedom, the loss of her life as she knew it. I'm talking about the mental anguish and the suffering that she is going through, that I've observed. She is so remorseful for what she's done. If she could take it back, she would. And I've witnessed her great suffering. And her suffering began when this happened, and it's going to continue well after whatever imposition of sentence or whatever sentence this court gives her. She'll continue to be punished in that sense. So, I believe that the sentence that I'm requesting also satisfies the objective of punishment here. We come to the objective of rehabilitation. And as I speak to this objective and talk about my client's past, I want to be clear that my client knows what she did was wrong. And we're not seeking to justify her actions. We're not putting this out there as some kind of a defense. What we're going to talk about is simply a reason to exercise mercy in this case. And I believe that she's someone that we as a society don't need to throw away. She is a human being who can still be rehabilitated, come out and live a useful life, and have a life that has meaning still, despite what's happened here, despite what she did. That can happen. And the ball's in her court in a great respect, because if the court imposes the 10 years with indeterminate time over and above that, the Department of Corrections will make their own assessment as to whether she is ready for parole. And if they don't feel she's ready, they won't let her out. The ball is going to be in her court to demonstrate that she's ready, that she's done the work, that she's paid the price that she needs to pay to be able to come out. So why do I think she can be rehabilitated? As I look at her, I look at the difficulties she's had in life. She was born to a teenage mother. And while I acknowledge they've done a lot of work to repair their relationship over the years, that was not a good situation. It was abusive for my client. Her father was not there. He wasn't a factor in her life, at least not much at all. Not much at all. Her mother did not care for her like a mother should. And as we look at the evaluation done by Dr. Hatzenbuehler, that had a significant, at least she made a significant tie to the conditions that my client's suffering from now that she's been diagnosed with bipolar disorder. Or, I'm sorry, borderline personality disorder. But that's not the only thing she had to to deal with. She had to deal with what that produced in her life is this disorder that really made it challenging for her to form relationships with people that were stable. Really made it challenging for her to have a stable life. Made her subject prone to impulsiveness, prone to relationships that would be abusive, prone to be in relationships that are stormy. And she did experience that. In fact, every relationship that has been discussed in the evaluations and the pre-sentence investigation was of that nature. Abusive, stormy, unstable. And what I see in that for my client as a positive is that she hasn't given up. She has always tried to have a life with meaning and do the best she can despite the difficulties that she's having. One thing that really stands out to me is she has done so much work in treatment for her mental health. Electroshock therapy, counseling, medications, myriad different things. And I think that in the evaluation from Dr. Hatzenbuehler, she indicates, yes, she's tried so many different treatments and they've always attempted to treat symptoms. She's never had treatment for borderline personality disorder, which to me is a silver lining. That tells me that she can engage in treatment that is going to help her. And that could get her to the point where she would be able to come back out once she's paid the price that she needs to pay. And my assessment of her, as I've spoken with her, is she's ready to do that work. She wants the help. She wants to do better. And I believe she can do it. One other thing that I see in her is, you know, this act here is one of the most horrific ones I can think of. There's that side of it. But then, I've seen a different side to Melissa. My interactions with her, through my interactions with her and through other people, I've seen that she has the capacity to be kind. She has the capacity to be loving. She has the capacity to reach out to others. I know that down in the jail, she's been a confidant for many people. Many other inmates have sought her out to talk to her because she has a listening ear. And she's been willing to listen to them and help take their burdens off, even though she's carrying a huge burden herself. It's particularly striking to me that as a child, an 8-year-old, she took care of her brother, her baby brother, because her mother was not there emotionally to be able to do that for some time. She fed him. She changed his diapers. She's an 8-year-old. Whatever that effect that had with her disorders, I don't know. My guess is that had a significant impact. But what that bigger, the more important thing to me is that demonstrates to me.
Mr. Murdoch, just a minute.
Yes.
Mr. Mercado? Mr. Mercado, 2 rows back. Young man on the end. Thank you. Go ahead. He doesn't need to leave, he just needs to be quiet.
Your Honor, what that speaks to me is that she has the capacity to be caring and to be loving. Although she did not demonstrate it on this occasion, the night that Jace died, she's demonstrated it before in her life, in many times. I submitted to the court earlier letters on my client's behalf. And I I don't believe we addressed those, but I'll address them now. And I would ask the court to consider those. I'll ask that they be marked as an exhibit. They can be one exhibit, and have the court consider them. Those letters speak to the kindness, to the goodness of my client and her humanity, and how she's touched other people's lives for good. With treatment, that will be brought out to an even greater degree, I believe. I'll hit on this also, and I've mentioned this before, but the fact that she has no criminal history speaks well of her potential to be rehabilitated. I don't believe she has criminal, that she's out to blame the rest of her world for her problems or for her actions. She takes them on. She takes responsibility for what she did. And I don't expect that she's going to ever have another criminal charge on her record. She worked to support herself up until this happened. She would like to return to school and learn a trade or have an occupation that she can have to provide for a better living for herself. And she can do that. She can learn a lot of that while she's in prison. But she does have goals. And I believe she's demonstrated that she's a person that can overcome adversity and challenges, and that she can return to society rehabilitated and contribute to other people's lives, as well as have a meaningful life for herself. And I believe that the sentence that I am requesting with the court, that the court impose, will achieve all the objectives of sentencing. I would ask the court to impose that sentence. Thank you.
Thank you. Mr. Rogers, state's recommendation.
Unfortunately, Your Honor, I've been involved in several murder cases with my job at this point. And this one's pretty unique because normally we get a case and a file comes up and we look at pictures and we read interviews and all the documentation. This was the first time in my experience where there's video of the victim passing away in a hallway while he's banging on doors and asking for help. The hallway, in my estimation from the video, 50 to 75 feet long. And as he is stumbling down the hallway to the end of the hallway, he's banging on the doors and people are poking their head out. They don't know. Everyone's timid, so they don't know what to do. Somebody ended up calling 911. While Jace is sitting at the end of the hallway on the video, you see Melissa Perkes exit the door and go out the back way while he is screaming. So that, you know, I don't pretend that it has any overwhelming effect on me like the family is going through. But for someone to come to work and witness the death of an innocent person is pretty dramatic. And it's been on my mind quite a bit since I've had to watch it. I can tell you what that does for me, and I can tell you what it should do for the court. It does not warrant a 10-year fixed sentence. There's been some words that have been said, just to highlight what I believe of this. This is horrific. Watching that was horrific. Having to deal with this as the family members is horrific. When I go through the PSI, the theme I pulled out of this PSI is avoidance. So we've heard the argument that Ms. Perkes takes responsibility. I do not believe that. The soul of my argument comes mostly from page 9 of the PSI. And there's two things that just stand out to me that are inexplicable. First, she talks about, when we got here today, there were some corrections made to the PSI, and during those corrections, the sentence or the phrase was mentioned, she remembers some detail. But when I look at page 9, she remembers great detail up until I heard the front door shut. I wasn't going to wait for him to come back, so I left. Then I was driving in the mountains. And then when you go down to the very middle paragraph that starts with looking back, the last sentence in that paragraph, the last two sentences in that paragraph. This is her statement. This loss affects everyone, ... This loss? No, her actions affected everybody. The last sentence.
Which page are you on?
On page 9. The last sentence of that middle paragraph. It's a devastating event that will take time to heal and cope with. It's a devastating event. She's not taking responsibility in both of those sentences. And if there was ever a time to take responsibility for it, it's when you're getting a pre-sentence investigation done on yourself. When I go through the rest of the report, it just feels like she is avoiding letting us in on what actually happened that night. This is not a 10-year sentence fixed. When we sat down with the family to talk about coming up with some type of an agreement, the idea was to let the PSI kind of come to us so I could figure out what to do for an indeterminate time. And I agree with Mr. Murdoch. I believe that rehabilitation is a big factor here. And it's going to be an incredible hurdle to overcome. But for me, it's the fourth out of the 4 elements that we look for sentencing. It's the least one I'm worried about. Deterrence and punishment are on the top of the list here. It was said that she has the capacity to be kind. Well, I don't know how many people are in the courtroom right now. Every one of us have the capacity to be kind. Also, every one of us have the capacity to murder. But out of everybody in the courtroom, only one person has acted on that. We have got to deter society from acting on our capabilities. It does not matter to me that she has no criminal record. This is the worst crime of all crimes that she committed, and it starts somewhere. And there was an argument made that she's never going to commit a crime again. But when we go through the PSI, already she's being reprimanded in the jail for passing notes. Like, she's not learning her lesson, and she's dealing with the crime of crimes. So I was hoping that the PSI would speak to me and let me kind of figure out what to do for an indeterminate time for this person that has no record, that can be rehabilitated. But it did nothing for that. A crime of this magnitude deserves life, indeterminate. So we are asking the court for 18 years fixed and life indeterminate. Thank you, Judge.
Mrs. Perkes, do you wish to make a statement on your own behalf?
Yes.
Go ahead. Make sure you speak up.
I want to say thank you for letting me have a moment to just address the court. But there is not, and never will be, a morning where I wake up or a night where I go to sleep without an overpowering feeling of regret and sadness for the loss and the pain that my actions have caused so many people. That is nothing less than what I deserve, and I pray that one day there will be some closure for anyone who loved Jace, including myself. I am to Brenda's family and his children of their loved one and their father, and I humbly accept whatever sentence the court imposes. I also know that no amount of restitution can bring him back, and I hope one day that I can appeal for forgiveness from you all.
Thank you, ma'am. Ms. Perkes, are you satisfied with the representation Mr. Murdoch's provided to you?
Yes.
Do you know of any legal reason why I should not sentence you today?
No.
Mr. Murdoch, do you?
No, Your Honor.
Mr. Rogers, do you?
No, Your Honor.
Ms. Perkes, based upon your plea of guilty, does the judgment of this court you are guilty of the crime of murder in the second degree? When I sentence an individual, I must consider the objectives of criminal punishment adopted by the Idaho Supreme Court, which includes protection of society, deterrence, rehabilitation, and punishment. In addition, I'm to consider the criteria under Idaho Code 1925-21 relative to the question of whether I should place you on probation or confine you in prison. I've considered those factors. I'm going to go through each one of those factors with you today. Before I do that, I want to address some things. I'm probably going to approach this in a different manner, where I'm going to go through the PSI and the report to outline some of the highlights that I've seen in order to address those issues under 1925-21. To understand for the general public and those that are here to understand sentencing, Idaho has a uniform sentencing model that they follow, which means a court will sentence an individual, give that individual a fixed time in most circumstances, whereby that individual is required to serve that time before they are eligible for parole. There then is a parole board who evaluates that individual to determine whether they can be paroled at that point during the indeterminate period. If they are paroled and then violate the terms and conditions of parole, the parole board can bring them back up to that indeterminate period of time. An individual may get several opportunities at parole depending on the nature of the violations and their progress towards rehabilitation. These are difficult cases to sit and make judgment on what the appropriate sentence should be. And I say that because of the emotions that are involved on both sides. It's easy and understandable while any victim of a crime or victim's family of the crime, especially in a murder case, come in and say, impose the maximum and fix life. Nobody's asked for that here. but some of the letters have a significant amount of fixed time, and that book should be thrown at them. The general public as well, oftentimes after seeing a sentence that's imposed, not understanding the criteria that the judge has to evaluate, demands oftentimes higher punishment than what perhaps is imposed. And I understand those. And so, as a court, however, I cannot sentence an individual based upon public sentiment or emotion. I am required by law to first consider probation and talk about that in any case, unless there is a mandatory fixed term that's imposed or required by law. But I am to weigh those factors, and we'll talk about those factors in just a moment. So I'm going to turn to the pre-sentence report. Oh, the other thing that I want to say is the victim's family in this case may hear some negative things about Mr. Williams, and I don't say any of these things to be disrespectful to him or to them. These are just the facts that are being brought through in the various reports and that I have to consider. Ms. Perkes is 36 years of age. Under her version of the events, she indicated that she was on November 7th of 2022. They were walking home from Bridge Street. She indicates that Jace was picking a fight with her, accusing her of cheating and calling her all kinds of names and being rude. They went home, the arguments continued. She went in to take a shower, and when she got out of the shower, he had put a knife on the pillow. She remembers grabbing it and asking, and I'm not going to say the word, but what he meant. And he told her just to kill herself because she's nothing but a dumb, and uses some expletives. She indicates she threw the knife down, was not fighting with him. They get into a physical altercation to some degree. She then went to leave, to get up and leave, and he threw the phone. I remember being back at his side of the bed, asking and begging him to stop. Remember him hovering over her with a knife. Indicated that she was going to die as well as him. He then gets off. She hears the door open and shut. She decides to leave and remembers driving in the mountains in an attempt to drive off a cliff. She then ends up at her mother's, and that's when she finds out that Jace had died. And she indicates that she doesn't know what happened that night. And as has been clarified and as is outlined more, particularly in the psychological evaluation, she doesn't remember the stabbing event. And we'll talk about that in relation to what Mr. Rogers pointed out. Her LSI is a 25, put her in a moderate risk category. The LSI is a tool used by the department that evaluates an individual's need for treatment as well as the risk of recidivism. It looks at various domains in a person's life: criminal history, companions, emotional, attitudes and orientation, family and marital situations, alcohol and drug problems, and education and employment, leisure and recreation, financial and accommodations. Those are what we call domains. And they look at those the information that has been presented, which is typically self-reported. Some of it is backed up by outside information that the PSI writer acquires. And then based on that tool, a score is given. And in this case, it's a 25, puts you in the moderate risk. That means if you were placed on probation or sometime in parole, of course, if you were paroled, they would then do this assessment again to determine if anything has changed. Then the probation officer and the parole officer would know what areas of your life to start to engage in rehabilitation and what programs you should be into. But it's also an indication that if you're don't receive those rehabilitative programs, what your risk is to society as well, or rather to commit another crime. As has been indicated, this is your first felony offense. As to companions, there's an indication that most are involved in criminal activity, meaning marijuana use. You've been diagnosed with psoriasis, arthritis, fibromyalgia, and lupus. You describe your mental health as depressed. You were diagnosed in 2018 with PTSD, major depressive disorder. You've attempted suicide on at least 2 occasions. When it comes to your family relationships and that history, as Mr. Murdoch pointed out, the information shows that you had, quite frankly, a traumatic upbringing. You were in various relationships, including that one, which were abusive, both physical and verbally. We'll talk about that a little bit more. You have been diagnosed as having alcohol use disorder moderate with a level 1 recommendation for treatment, which is the lowest recommendation other than no treatment. You graduated from Blackfoot High School in 2005. You attended some technical college, and it's been explained why you didn't pursue that here today, as well as in the report. PSI writer in the recommendation section says, premeditation was not established, but the act appeared intentional. Therefore, I respectfully recommend that Melissa Perkes be sentenced to a period of incarceration with the Idaho Department of Corrections. I'm now going to turn to psychological evaluation. The psychological evaluation was conducted. In this case, the report was dated May 28th and filed with the court on July 3rd of this year. Dr. Hatzenbuehler has diagnosed you with borderline personality disorder. Individuals with borderline personality disorder demonstrate long-standing behavior characterized by a pattern of intense and stormy relationships, uncontrollable anger, poor impulse control, affective instability, identity and cognitive disturbances, and recurrent suicidal behavior. Further, impulsivity, poor anger control, mood instability, and self-defeating behavior impair their social functioning and cause personal distress. That diagnosis, with the information contained in the report, describes you to the T. Dr. Hatzenbuehler concludes that there's clear evidence that you were emotionally abused by your biological mother. You meet the criteria for substance use disorder. There was no evidence uncovered during the evaluation to indicate that you had abused substances, any other substances, including prescription medications, but you had been abusing alcohol on the evening of the events. In paragraph number 5 on page 2, at the time of the events leading to her charge, Ms. Perkes appears to have experienced a localized dissociative episode, as she has no clear memory of the specific event leading to her charge. Dissociation is not an unusual experience for individuals with borderline personality disorder. So you have reported that you don't remember the specific stabbing portion of that evening. Only you know whether that's true or not. Mr. Rogers, in his argument for whether you're taking responsibility or not, at least in my opinion, is to some degree arguing that you know more than what you're telling. I don't know. And if he's not saying that, that's fine. I'm going to address it. But it's what I'm saying is that if that is in fact true, it coincides with the diagnosis that Dr. Hatzenbuehler has provided to this court. In the summary of her findings, she says Ms. Perkes is a 36-year-old female who has been charged with causing the death of her intimate partner at the time. Their relationship appears to have been a volatile one, and there is evidence that Mrs. Perkes and her partner engaged in verbal and physical altercations intermittently during their 2-year relationship. Law enforcement reports that were made available to Dr. Hatzenbuehler indicate that officers have contacted you several times, primarily for welfare checks, following suicidal threats on your part and at the time of domestic arguments. And that again ties into the diagnoses that you've been given, not only by Dr. Hatzenbuehler, but others. You had issues where in 2017 Child Protection Services was called because you bit your younger daughter on the hand. There was a report that you were physically and verbally abusing your children in 2018, or children in 2018. In 2019, officers were called regarding an incident where you engaged in a verbal argument and you punched the individual in the face. In 2021, you were involved in an argument with Mr. Williams at an intersection. They were called there. 2022 in February, they were called because you threatened to kill yourself. Again, in February 2022, you engaged in suicide attempts. And this incident occurred shortly after officers had responded to the argument that you had with Mr. Williams on the street. So again, the behavior during those incidents ties right in with the diagnosis of that Dr. Hatzenbuehler has provided. On the night that Mr. Williams was stabbed by you and killed, you indicate to Dr. Hatzenbuehler that you guys were at the bar till about 11 p.m. And then I've already rehassed things that were discussed leading up to the stabbing. Dr. Hatzenbuehler states, at the time of the events leading to Mrs. Perkes' charge, it appears based upon her reports that she was intoxicated as she had been drinking for several hours and had not ingested any food. She indicated in addition that she was angry at her partner, chose to sleep in another room where she saw a knife on the pillow in the room where she typically slept with her partner, and become fearful. In response to her partner's demeaning comment to her, she thought of suicide and planned to die at his favorite place in the mountains so that he would remember her when he went there. At some point during the events leading to Miss Perkes' offenses, it appears that she experienced a dissociative reaction, as she indicated that she now has no memory of many of the details of her activities associated with her offending. Dissociative amnesia is one of a group of conditions called dissociative disorders. They are mental illnesses in which there is a breakdown of mental functions that normally operate smoothly, such as memory, consciousness, or awareness, and identity and/or perception. It's been linked to overwhelming stress, which may be caused by traumatic events, and a person with dissociative amnesia may have experienced the trauma or witnessed it. In Miss Perkes' case, she appears to have both experienced and witnessed a traumatic experience, and her memory loss appears to be focused on her specific trauma, because although she has no memory of harming her partner, she can recall details from both earlier in and during the rest of that day. On the profiles or the testing that was done, you're going to be impulsive, may act without considering the consequences of your actions. You're likely to be impatient, you have a low frustration tolerance, and then find yourself repeatedly in the same difficulties. You're somewhat immature and self-centered, and consequently, you are insensitive to the needs and feelings of other people, and you're prone to be interested in others only in terms of how they can meet your needs. The profile further suggests that you may harbor feelings of resentment and be prone to aggressiveness. Under the, what's called the personality assessment inventory done, you had significant elevation on the subscale, which measures your individual tendency to become involved in relationships that are very intense and chaotic, and that's been your history. So in the recommendations, it indicates that you remain a suicide risk given your history. And that requires ongoing monitoring of your suicidal thoughts. Psychotropic medications don't cure borderline personality disorder, but they can help ameliorate some of the symptoms, such as mood instability. You should be required to continue to take the medications under supervision of a mental health trained prescriber. But the main focus in treatment for an individual with borderline personality disorder is dialectical behavioral therapy, or for short, DBT. In this case, the court must consider, if it imposes a sentence, a minimum of 10 years of imprisonment. That imprisonment may extend to life. Under Idaho Code 1925-21, the legislature has declared that the policy of the state of Idaho regarding sentencing of persons convicted of a crime is as follows, unless otherwise provided for by law. A, the sentencing court should first consider placement in the community. The goals of sentencing include primary consideration of protection of society, followed by the possibility of a risk reduction through rehabilitation, deterrence of the individual and the public generally, and punishment or retribution for wrongdoing and the impact on the victim. Each discretionary sentence should be specifically tailored to the individual defendant and take into account the totality of all relevant facts and circumstances. We then go to subsection 2 that outlines the various factors that I have to consider. Though while not controlling the discretion of the court, weight shall be accorded in favor of avoiding a sentence of imprisonment under these factors. First, A, the defendant's criminal conduct neither caused nor threatened harm. In this case, it did. Thus, this factor does not favor something less than imprisonment. Subsection B, the defendant did not contemplate that the criminal conduct would cause or threaten harm. This factor gets a bit more complicated and ties to the psychological or mental condition of yourself, as well as other dynamic factors such as the domestic situation that you and Mr. Williams were in, substance abuse issues relative to that situation, and the domestic abuse that was occurring. When you look at Dr. Hatzenbuehler's report, and if I take that as true, that you have that dissociative amnesia, then you weren't aware of your act at that particular time, but you still made the decision to pick up that knife and stab him. In addition, after that happened, and you walked out the door, a significant factor to me is that even though you may have still been in that state, you chose to leave rather than to render aid. Therefore, under this analysis, the court does not, this factor does not favor something less than imprisonment. We talked about the LSI score and your criminogenic needs, and that's the next factor the court is to consider. And that's whether you would benefit from supervision and treatment in the community. In most circumstances, treatment or rehabilitative programs are more successful in a community setting. And that's proven over and over again, and particularly in substance abuse cases, and that's why we have these specialized treatment courts in the state of Idaho. In this case, you've been assessed as having an alcohol use disorder. You're in need of level 1 treatment. It's pretty minor treatment, and that can be done most successfully in a community setting. Doesn't mean it can't be done in an imprisonment setting. But that's not the underlying concern. My bigger concern on rehabilitation is that you get into the dialectical therapy, the DBT. That too can be done in the community setting. But the diagnosis that you've been given is not only a mitigating factor, but it can be an aggravating factor, because if it's left untreated, that instability in your life and that chaotic relationships that you tend to get into still put society at risk. Therefore, under this analysis, this factor as well does not favor something less than imprisonment. Under paren D, I have to look at whether there's substantial grounds tending to excuse or justify your criminal conduct, though failing to establish a defense. This factor too can be a bit tricky given the apparent domestic relationship between you and Mr. Williams in this case. Being involved in the criminal system since 1995, it's very apparent to me and I'm sure to Mr. Rogers and Mr. Murdoch, probably even those here, that domestic relations can bring out the very best in us, but they can also bring out the very worst in us. Because they bring emotions that seem sometimes uncontrollable. In this particular situation, when you couple emotionally abusive nature of your relationship with Mr. Williams on this particular night, along with your psychological situation and the apparent use of alcohol, one could argue that there may be grounds to argue that you were provoked to some degree. However, when it comes to taking a life, given the facts surrounding this case, there are simply no grounds to excuse or justify your criminal conduct. In addition, there does not appear to be any grounds whereby in defense to your actions could be asserted under the facts as presented to this court. Therefore, under the court's analysis, this factor does not favor something less than imprisonment. Under Perenni, I have to look at whether the defendant's conduct induced or whether the victim of your conduct induced or facilitated the commission of the crime. As indicated, if your actual scenario is to be believed as to what took place when Mr. Williams' life was taken, this factor could cut to some degree in your favor, because there appears to be some provocation by him. An argument had been taking place. Assertions were made over your alleged inappropriate behavior. He then placed a knife on your pillow, made some suggestions on what you should do to it to yourself. In other words, that you should take your own life. So it could be said that at a minimum, Mr. Williams pushed your buttons that riled your emotions to the point that you killed him. So under that factor, one could argue that that is a factor that could weigh somewhat to your benefit. But it's not an overwhelming factor in my mind, because you still chose to take somebody's life. Under subparagraph F, I have to consider that whether you'll compensate the victim for your conduct. And that's a pretty easy one to answer. The answer is no. You can't bring him back, and that's the only way you can ever compensate, is if he could come back, and he can't. And so therefore that factor does not favor something less than imprisonment. Paragraph G, I have to look at whether you have a history of prior delinquency or criminal activity, or that you've led a law-abiding life for a substantial period of time before the commission of the crime. That's an easy answer as well. This is your first conviction of any kind. And so that goes to your, as a mitigating factor to you and to your benefit. As Mr. Murdoch argued, you've been an upstanding citizen for 36 years. So this is a factor that could argue for a sentence less than imprisonment. Under paren H, I have to consider whether your conduct was the result of circumstances unlikely to reoccur. This is a factor that really is unpredictable. If you look at your criminal history alone, you could answer that yes. And that's really what Mr. Murdoch has answered or argued, is that because you don't have a criminal history, that a minimum fixed period of time is appropriate under this factor. However, there is that risk factor as well, that without treatment, like the DBT that we talked about, and that you're able to apply that treatment and deal with your mental health issues, under Dr. Hatzenbuehler's analysis of how one behaves with that issue, you are likely to become involved in similar tumultuous relationships where such behavior could occur again. And so this factor really kind of hits in what I'm going to call the neutral ground. have to look at whether the character and attitudes of you indicate the commission of another crime is unlikely. Usually when I sit here, I'm a pretty good judge of character. When I listen to somebody, can tell whether being straightforward with me or not. I can get fooled, and I do get fooled, and I miss it sometimes. But I haven't been able to get a real good read on you. When I've reviewed the letters from individuals sent from the victim's family and from your friends and associates, I'm not surprised by what I see. Victim families will submit letters, as they have in this case, outlining the positive things of the person that they lost. And that's expected, and I understand it. And then they also point out the negative things as to you. There really weren't a whole lot of negative things said about you, with the exception of one or two letters. In your case, the letters were submitted that indicated you are a great person, that you're caring, that you've helped them. They also outline the fact that you've suffered a lot through your life and the traumatic experiences, both as a child and the relationships that you've had. And at least one of them, maybe two, indicated an awareness of the abusive relationship that you were in, and noted those negative aspects of Mr. Williams. And so the record is clear. Mr. Murdoch and Mr. Jolly, prior to sentencing, joined me in my office and submitted those letters so I could read them before sentencing and stipulated to their admission. And I'll talk about those letters directly on who wrote them in a minute, but they're Defendant's Exhibits A through H. So, I've kind of given you the benefit of the doubt on this one. I think you've shown some remorse. I think you understand what you've done is wrong. And you appear to take responsibility at a minimum through your plea of guilty in this case. Then I have to look at J, whether you demonstrate an amenability to treatment. And the answer to that is that you do, and therefore one could argue a sentence less than imprisonment. Then we go to subsection 3 of 1925-21. And it says the following factors, while not controlling the discretion of the court, shall be accorded weight in favor of a sentence of imprisonment. In other words, the prior section said I should look at these and really try to put somebody on probation. This one says look at these factors, and these factors, depending on how I weigh them, should favor prison time. Under subsection A, I have to consider whether there is an undue risk that during the period of a suspended sentence or probation, you will commit another crime harmful to another person. I've addressed that under factor 2C already. I'm not going to repeat myself, but that factor would tend to indicate a sentence of imprisonment because I have no way to know whether treatment would be successful in your circumstances. B is probably the biggest factor for me, and that is a lesser sentence would appreciate the serious nature of your crime. The answer is an obvious yes, and therefore cries for a period of incarceration. I have to decide under subsection C whether imprisonment will provide an appropriate punishment and deterrent to you. Deterrence is a real debatable factor. If imprisonment is to deter, it did not deter you. And unfortunately, in the future, it most likely will not deter others. However, it will deter most people. The court must, however, analyze deterrence as to you. It did not deter you in this case, and I'm sure that you, as do most people, know that taking a life would subject you to imprisonment. However, at that time, you did not contemplate that. You acted on impulse. And according to Dr. Hatzenbuehler at the time, were in a dissociative state. And therefore, you were not deterred. So then I need to look at, after a term of imprisonment, should you be eligible for parole at some point, what amount of time would deter you in the future? Mr. Murdoch has said 10 years. Mr. Rogers is saying 18. I don't know yet what way that should go. Therefore, under this factor, it's kind of a neutral factor. I then have to look at D, whether imprisonment will provide an appropriate deterrent for other persons in the community. The answer to this is it should, and therefore it weighs in favor of imprisonment. If the subject of imprisonment were a true deterrent, nobody would come before this court on a crime. But there are a lot of different factors as to why people commit crimes. There's a criminal thinking method that goes into why they commit crimes. There are behavioral issues as to why they commit crimes. And that's why when a judge sentences an individual, they have to look at the individual that they are sentencing and not as a whole. You have to look at whether you're a multiple offender or a professional criminal. You're not. And so under paren D and E, both of those would weigh in favor of, under D it would weigh in favor of imprisonment. Under E, whether you're a professional criminal or not, looks at a sentence other than imprisonment. So those are the factors I have to consider. I don't have to base my decision on whether a majority of the factors favor imprisonment or something less. I can, in my discretion, give more weight to any one factor over the other. So as we've discussed, you're 36 years of age, your first felony, your LSI is a moderate, your need of substance abuse treatment, mental health treatment, you have the borderline personality disorder. The PSI recommends prison. In addition, as I've indicated, I've considered the victim and the victim's family in this case. I've considered those who have made statements here today. And I've considered the letters that have been submitted. On behalf of Mr. Williams and his family, I've read and considered the letter submitted by Stacy Staples, who was an aunt, James Norris, a cousin, Tim Sanch, a cousin, Hilton Crowell, a friend, Eric Heiner, a cousin, Mildred Spencer, an aunt, Susan Williams, a mother, Lloyd Williams, a father, Ty Davis, a friend, and Harley Williams, a daughter. Now, on Harley's letter, I could not read it because of how it printed out, but the letter was transcribed before it got into the PSI, and I read that letter after it was transcribed in the PSI. There's been objection to those who are not family, and I've allowed them, but the letters from the particular friends that you've objected to have not had an impact on my decision here today. Rather, I have had more impact from my review of the information contained in the evaluation, the other things contained in the report other than the letters, and analyzing those significant factors in relation to 1925-21. On behalf of Ms. Perkes, I've looked at exhibits A through H. Those are letters from Angela Clark, a friend, Paula R.G. Crusby, if I'm saying that right. I'm probably butchering it, but it's MARUGI-KRUPSKE. Denise Mickelson, a friend, Mariah Coleman, a friend of Ms. Perkes and Mr. Williams, Abby Wheeler, a friend, Lorena Avina, a friend, Chris Dewey, a friend, and Chantel Wallace a friend. Again, the letters have not made a significant impact on my decision here today. The one thing about the letter that was submitted by Mariah Coleman seemed to back some of the information about the nature of this relationship. So that was about really the only interesting thing, other than I understand their feelings, and I don't tend to demean their recommendations or their information. I've looked at them, I consider them, but I'm more focused on the elements outlined in the statute. Now, we want to see the best in those that we support. So as I indicated, I'm not surprised by the letters provided to me from each side. Understandably, some have asked that I impose the maximum fixed penalty. I spent a lot of time thinking about this. And in doing so, I've gone back and I've looked at various cases in Idaho on when a life sentence fixed is appropriate. And I don't mean to diminish Mr. Williams' life in any respect. And murder is a heinous crime. As Mr. Rogers indicated, it's one of the most horrible ones that we deal with, and quite frankly, I'd rather do something else today. But when you look at the sentences where life fixed is imposed, the manner of the murder plays a significant factor in that. And I don't have another word, but a more heinous nature of murder, so to speak. There are two sentences that I can think of in Bingham County that I've handled. And I issued a fixed life in one of those, but there was no question in my mind that that individual that appeared for me was pure evil. I don't see that with you. Another case that I had a few years ago, the relationship was similar to where you were at, where a man ended up shooting his wife. He was older, there were different factors involved, but I did not give him fixed life. Given his health and his age, he didn't serve a whole lot of time and he passed away in prison. There are many factors in 1925-21 that would indicate I'm not looking at probation or at this point I'm looking at prison, but I'm looking at those factors to say, okay, where should the fixed period be? And there are some that would indicate that a fixed sentence, in my mind, of at least 15 years would be appropriate. I'm not sure that that's where I'm at. Mr. Murdoch seems to think that 10 is. The state seems to think that 18. And so I've debated between, quite frankly, that 15 and 30-year period. There's no question in your case that probation is not appropriate, detained jurisdiction is not appropriate. And so I got to figure out what the fixed term should be. There are some things that have kind of tipped the scale for me. Number one is that murder is just a serious crime. Number two is the fact that when you walked out, you didn't render aid, you kept going. I don't know what was going on in your mind. Apparently you were in a disassociative state. If that's the case, you may not even know where he was at. You just went out, you were going to go. But it's what doesn't jive with me on that, and we don't have the expert here to deal with that, is why would you be thinking then, and no, I'm going to go to this exact spot, and I'm going to kill myself knowing that he will go there and think of me. Either that or he won't go there at all. But if you're walking out that door with that thought process, I guess that's possible under Dr. Hatzenbuehler's analysis. But it still bothers me that you're able to walk out that door and disregard him completely. I also have concerns that unless you truly engage in DBT, substance abuse treatment, that you're going to end up in another abusive, chaotic domestic relationship. And if that's the case, then you put that individual, even if it's the most horrible individual on the earth, at risk, because nothing can justify murder unless it's in self-defense. I probably talked way too long. But as I indicated, this isn't an easy decision. I have an idea where I want to be, and I'm trying to figure out where I should be. And I'm hoping that you and those here understand my thought processes on where I end up. Based upon all the facts and circumstances, it will be the judgment of this court that you be sentenced to the Idaho Department of Corrections for a fixed and determinate period of 24 years and an indeterminate period of life. In other words, not less than 24 or more than life. You're fined the amount of $15,000. Court costs are $245.50. You'll reimburse the county for the services of the public defender in the amount of $500. Rogers, was there restitution requested here?
Your Honor, if we could have 30 days to submit that to the court.
So I think you had something submitted.
I just need to check to see if it's finalized. I don't know if it's finalized at this point.
So there was a motion for reimbursement to the crime victims' compensation for $15,185.
And that was, we've had some days since then, so I don't know if it's gone up.
Mr. Murdoch, do you wish to address that later, or do you have any objection to the current request of $15,185.54?
We do not have an objection to the current request.
Based upon that, I will order reimbursement to the victim's crime compensation in the amount of $15,185.54. I will leave it open for amendment of additional funds if necessary. You'll have 30 days to file that request. Mr. Murdoch, you'll have 45 days to object. If no objection is made, I'll consider it a stipulation. Otherwise, you'll need to object and we'll set it for a hearing. There was also a motion for reimbursement to forensic services in the amount of $2,000. Is there any objection to that? Looks like that was for DNA testing of 4 items.
Your Honor, I don't have that one.
All right.
I guess I would request that.
I'll consider that an objection at this point. If you determine otherwise, file stipulation within 30 days. Otherwise, I'll get a hearing set. There was also a motion for restitution for the benefit of Susan Williams in the amount of $1,950. Any objection to that?
That's for the lost wages?
Yes.
Can I have a moment with my client?
Yes.
Your Honor, we do not have an objection to that request.
Without objection, that amount would be ordered as well. Now, Ms. Perkes, do you understand the sentence I've imposed?
Yes.
Do you have any questions about it?
I do, but I don't know if those are questions that I ask you or speak.
Okay, I'll turn on the white noise and you can ask those of Mr. Murdoch. Let's find out if you need to ask me or him. Mr. Murdoch?
Your Honor, the questions that she had are better for me, and we'll talk about those later. It's nothing that we have to bring up right now.
Ms. Perkes, I'm going to give you some time frames for some post-conviction motions that you can file. So I need you to listen to them very carefully. You have the right to appeal my decision here today. That appeal has to be filed within 42 days. If you cannot afford counsel, you can apply to have counsel appointed to represent you at public expense. You just remember that you only have 42 days to file that appeal. You understand that time frame?
Yes.
Now, you may also have the right to seek relief under Idaho Criminal Rule 35. Mr. Murdoch can explain to you the basis for that motion. You have 120 days to file that motion from the date of entry of the judgment. Do you understand that?
Yes.
So the judgment will most likely be entered tomorrow, could be entered today, but you'll have 120 days then to get it done. Do you understand that time frame?
Yes.
Now this one's the one that's more confusing. You may have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. It's a civil matter that you would file on your own or through counsel, not in this case, but in a civil filing. That has to be filed within 1 year from the date your appellate time expires. What that means, if you do not file an appeal, you have 1 year and 42 days to get that filed. You understand that? If you do file an appeal, you have 1 year from the date that that appeal is finalized to file that request. Do you understand that?
Yes.
All right. If you have questions on how or whether to file any of those matters, discuss those issues with Mr. Murdoch and he can advise you. Understood?
Yes.
In addition, under Idaho law, you'll be required to provide a DNA sample and thumbprint to the state. You understand that?
Yes.
All right. Mr. Murdoch, Mr. Rogers will get a restitution hearing set and we'll notify you that date. It'll be at least 60 days out, so I figure out whether you need a hearing or an additional motion or not, and whether you reach a stipulation on the other matter. There was also a request, I think, I can't find it right now, but reimbursement for the psychological evaluation, that'll be borne by the district court. So I'll deny that request. Mr. Murdoch, do you have anything further?
No, Your Honor, thank you.
Mr. Rogers?
No, Your Honor, thank you.
Ms. Perkes remanded to the custody of the Beacon County Sheriff's Office to be transported to the proper age and authority and execution of the sentence. That concludes the court's calendar this morning. We will be in recess until 1 p.m.
Please rise.